Patricia HALAGUENA, and other female flight attendants of Philippine Airlines, petitioners, versus Philippine Airlines Incorporated, respondent. GR number 243259. January 10, 2023. Facts. This court resolves the petition for review on certiorari assailing the May 31, 2018 decision and November 19, 2018 resolution of the Court of Appeals, which reversed and set aside the May 22, 2015 decision and October 9, 2015 resolution of the Regional Trial Court involving a stipulation in the collective bargaining agreement providing for the compulsory retirement of female cabin attendants at 55 years old and male cabin attendants at 60 years old, lacks basis, discriminates against women, and is void for being contrary to law and public policy. Patricia HALAGUENA, Ma. Angelita L. Pulido, Ma. Teresita P. Santiago, Marianne V. Catindig, Bernadetta A. Cabalcuento, Lorna B. Tugas, Mary Christine A. Villareet, Cynthia A. Staymeyer, Rose Anna G. Victa, Noemi R. Crescencio, and other female flight attendants of Philippine Airlines Incorporated are members of Flight Attendants and Stewards Association of the Philippines. It is the sole and exclusive bargaining representative of Philippine Airlines Incorporated's flight attendants, stewards, and pursers hired on different dates prior to November 22, 1996. On July 11, 2001, PAL and FASIP entered into a collective bargaining agreement incorporating the terms and conditions of employment of cabin attendants for the years 2000 to 2005, PAL-FASIP 2000 to 2005 CBA. On July 29, 2004, HALAGUENA et al. Filed a petition for declaratory relief with prayer for issuance of temporary restraining order and writ of preliminary injunction with the Regional Trial Court of Makati City, Branch 147, enjoining PAL from enforcing Section 144A of the PAL-FASIP 2000 to 2005 CBA. They sought the nullity of Section 144A for discriminating against female flight attendants in violation of the Constitution, the Labor Code, and the Convention on the Elimination of All Forms of Discrimination Against Women. PAL initially claimed that the Regional Trial Court lacked jurisdiction as the petition is a labor case disguised as a special civil action. However, the Regional Trial Court dismissed this claim in an August 9, 2004 order and upheld its jurisdiction. On August 10, 2004, the Regional Trial Court issued a temporary restraining order and ordered PAL to restore the status quo of Bernadetta, who will be affected of the provision. PAL heeded this and did not retire Cabalcuento but put her on an off-flight status. On September 27, 2004, the trial court granted the prayer for injunction. Issue is a stipulation in the collective bargaining agreement providing for the compulsory retirement of female cabin attendants at 55 years old and male cabin attendants at 60 years old, lacks basis, discriminates against women, and is void for being contrary to law and public policy. Held. Retirement has been consistently defined as the result of a bilateral act of the parties, a voluntary agreement between the employer and the employee whereby the latter, after reaching a certain age, agrees to sever his or her employment with the former. There are three types of retirement plans available to an employee. First is compulsory and contributory, which is provided for in Republic Act No. 828255 for those in the private sector and Republic Act No. 829156 for those in the government. Second is that voluntarily agreed upon between the employer and the employees in collective bargaining agreements or other agreements between them. And third is that voluntarily given by the employer, expressly as announced in company policies or impliedly as in a failure to contest the employee's claim for retirement benefits. The second and third types of retirement are governed by Article 302 of the Labor Code. Article 302. Formerly Article 287, Retirement. Any employee may be retired upon reaching the retirement age established in the collective bargaining agreement or other applicable employment contract. In case of retirement, the employee shall be entitled to receive such retirement benefits as he may have earned under existing laws and any collective bargaining agreement and other agreements. Provided, however, that an employee's retirement benefits under any collective bargaining and other agreements shall not be less than those provided therein. In the absence of a retirement plan or agreement providing for retirement benefits of employees in the establishment, a compulsory retirement age, who has served at least 5 years in the said establishment, may retire and shall be entitled to retirement pay equivalent to at least one half month salary for every year of service, a fraction of at least 6 months being considered as one whole year. In finding merit in the petition, we emphasize that the fundamental equality of women and men before the law is enshrined and guaranteed by the Constitution, statutes, and international convention where the Philippines is a signatory. Article 2, Section 14 of the 1987 Constitution mandates the state to actively ensure the fundamental equality before the law of women and men. Unlike the equal protection provision under Article 3, Section 1, Article 2, Section 14 requires the state to actively engage and promote gender equality. Thus, Article 2, Section 14 of the 1987 Constitution provides that the state shall ensure the fundamental equality before the law of women and men. Contrasted with Article 2, Section 1 of the 1987 Constitution's statement that no person shall be denied the equal protection of the laws, Article 2, Section 14 exhorts the state to ensure. This does not only mean that the Philippines shall not countenance nor lend legal recognition and approbation to measures that discriminate on the basis of one's being male or female. It imposes an obligation to actively engage in securing the fundamental equality of men and women. Meanwhile, Article 13, Section 14 commands the state to protect working women through providing opportunities that will enable them to reach their full potential. The Labor Code affirms the state's basic policy to ensure equal work opportunities regardless of sex, 75, and expressly prohibits an employer from discriminating against women employees solely based on sex. Article 133. Formerly Article 135. Discrimination prohibited. It shall be unlawful for any employer to discriminate against any woman employee with respect to terms and conditions of employment solely on account of her sex. The following are acts of discrimination. A. Payment of a lesser compensation, including wage, salary, or other form of remuneration and fringe benefits, to a female employee as against a male employee for work of equal value, and B. Favoring a male employee over a female employee with respect to promotion, training opportunities, study, and scholarship grants solely on account of their sexes. Considering the constitutional guarantee of protection to labor and security of tenure, an employer must convincingly establish through substantial evidence that there is a valid and just cause to terminate the employment of an employee. Substantial evidence, which is the quantum of proof required in labor cases, require such relevant evidence as a reasonable mind might accept as adequate to support a conclusion. In Dela Cruz Cagampan v. One Network Bank, Incorporated, this court found One Network Bank's no-spouse employment policy as discriminatory, since it failed to prove with substantial evidence the factual basis and reasonable business necessity for its policy. The trial court ruled that respondent failed to prove any difference between male and female cabin attendants, which justifies the implementation of the assailed provision. On the other hand, the Court of Appeals justified the difference in the compulsory retirement age for male and female cabin attendants as follows. In this regard, the CBA provision on early retirement for female flight attendants must be viewed in the context of PAL's obligation to guarantee the safety of its passengers, taking into account the obvious biological difference between male and female. It must be remembered that the task of a cabin crew or flight attendant is not limited to serving meals or attending to the whims and caprices of the passengers. The most important activity of the cabin crew is to care for the safety of passengers and the evacuation of the aircraft when an emergency occurs. Passenger safety goes to the core of the job of a cabin attendant. Truly, airlines need cabin attendants who have the necessary strength to open emergency doors, the agility to attend to passengers in cramped working conditions, and the stamina to withstand grueling flight schedules. Here, petitioners' act of vigorously pursuing this case all the way up to this court twice for almost 18 years completely negates the claim that they agree to retire under the compulsory retirement provision of the CBA. Even if embodied in the CBA, petitioners had no choice but to assent to the contested retirement provision, considering that Article 2, Section 3 of the CBA provides that the company will not hire a cabin attendant without their being completely subject to the terms of the agreement. This was assented to by their male-denominated union representatives, who failed to protect their interests and even testified against them. Thus, despite the incorporation of the retirement provision in the CBA and petitioners' receipt of retirement benefits, they cannot be stopped from questioning the validity of their retirement, since economic necessity and the prospect of unemployment compelled the employees to accept the benefits offered them. That the distinction has been historically and mutually agreed upon in previous CBAs does not impose any obligation on both parties to continually accept it. Considering that the Civil Code 103 categorically provides that contracts and its stipulations, whose cause, object, or purpose is contrary to law, morals, good customs, public order, or public policy, are void, Section 144A of the PAL-FACIP 2000 to 2005 CBA is void for being contrary to the Constitution, laws, international convention, and public policy. Petitioners are entitled to the reliefs they prayed for.